Hi, I'm Chris Kane. I'm a partner at Foley and Lardner, which is an international law firm. We are headquartered out of Milwaukee. We have about 1,100 lawyers across the country. I myself am a corporate lawyer, which means I don't go to court. I'm a business lawyer. I help clients with mergers and acquisitions, contracts, and I also do a lot of work in the technology and intellectual property space because I represent a fair number of startups. So today, I'm going to give you a quick primer, basics on what I call sort of intellectual property 101. Just enough to make you dangerous, recognize the key differences and the key concepts and the different types of IP, which I think will be helpful and educational. I've included a deck that will go along with my presentation. So at the outset, let's talk about what we mean when we discuss intellectual property, right? Intellectual property as opposed to, physical property, plant property, equipment, buildings, things like that. Intellectual property tends to be intangible. And the types of intellectual property are copyrights, trademarks, patents, and trade secrets. And I'll talk about each of those briefly in turn, and we'll try to compare and contrast one intellectual property from the others because they all do have various differences. So first, copyright. Copyright is probably encountered most frequently just because it is so broad. And generally defined, a copyright is any original work of authorship that is fixed, recorded in other words, in a tangible medium. So as I often say, or as others say, if you're writing something, once your pen comes off the paper or your finger comes off the keyboard, whether it's code, whether it's prose, whether it's a video, photograph, you have a copyright. A copyright now exists. The way I often like to describe it is a copyright is an expression of an idea. It's not the idea itself, but it's an expression of it. Again, think of a photo, think of a video, think of the written word, think of software code, think of a poem, a book. These are all examples of items that can be considered copyright or copyrightable. And you can see from the slide, the Wikipedia quote, it may be literary, artistic, educational, or musical. And the value of a copyright is once it's created, it gives the author the exclusive right to copy that work, distribute that work, perform that work, create derivatives of that work. A derivative is essentially taking a copyright and using it to create something else. That second piece of intellectual properties is what we call a derivative work from the original copyright. So again, from my perspective, the important thing to remember, it's very broad. Any original work of authorship fixed in a tangible medium, and it's really the expression of an idea. It doesn't protect the idea itself. And a good example, again, the slide points out too, is obviously this deck provided by Startup Guides is copyrighted, and so they control the copyright to it. I should also note, by the way, a lot of people wonder if you have to have that copyright logo at the bottom or copyright 2022. You don't in order to have a copyright, but it's considered good practice to put people on notice that you view it as something that is your intellectual property. Next, let's talk about a trademark. Now, the purpose of a trademark is to either by logo, design, or name, the purpose of a trademark is to uniquely identify in the mind of a consumer the origin of a source or a good, right? So think of like a lot of the brand names right? Like Kleenex or Xerox or Nike or Adidas, right? Atari. Any of these are trademarks. And again, the main purpose of them is to help you very quickly say, oh, yes, Nike, I know about that. It's a company that makes shoes and those are their products, right? So that's the value of a trademark. It's really helping you identify the source of a good or a product. And that's why it's very important to protect those rights. Someone could be, if someone takes your trademark and uses it to promote their own goods, that can obviously cause confusion in the marketplace. And you as the owner of a trademark would have the right to take action against that individual to prevent that, because that's now creating confusion in the marketplace. Because now when someone, if they're using your trademark illegally, that trademark is being used to identify a product that in fact is not yours. So that's why it's important to protect your trademark. And again, as the Wikipedia entry says from the slide, intellectual property consisting of a recognizable sign, design, or expression that identifies products or services. And again, that's important too. You can have what's called trade dress, right? So if you think about it, for example, one that I think of commonly is Yoplait yogurt. You know, they have that sort of unique design to their yogurt. It's smaller on the top and wider on the bottom, slightly triangular. That's an example of trade dress, where that's actually considered a trademark and it's part of the protected design elements of Yoplait's trademark in addition to the Yoplait name. So that's what a trademark is. That's what the purpose of it is. Another good example, obviously the Starbucks, both the name, right, the Starbucks name, and the logo. And in fact, you'll see there, you'll see Starbucks has a little circle R next to it. That means it's a registered trademark. You'll see the Starbucks logo has a TM. That means it's a common law trademark. And I won't go into details on that, but suffice it to say that to get a registered trademark, the circle R, that requires you to take a bit more action in the sense you have to file a document with the United States Patent and Trademark Office, and you sort of go back and forth with them proving or trying to prove that you're entitled to the registered mark. And if you get that circle R, the registered trademark, that gives you broader rights than the little TM. What the little TM means is that you have a common law trademark. And again, similar to copyright, remember where I said as soon as you sort of take your pen from the paper or your finger from the keyboard, the copyright is created. Similarly with trademarks, as soon as you start using a trademark in sort of the stream of commerce, right? So on your website, on your product, and emails, in advertisements, you start to have common law trademarks. So you don't have to file anything to get those common law trademarks, and those are what are represented by that little TM versus the circle R. Okay, moving on, let's talk about patents. Now, patents, remember I said with copyrights really protect the expression, the particular expression of an idea, not the idea itself. A patent gets closer to trying to protect an underlying idea in however many forms it could be expressed. It really gets more closely to trying to protect an idea. And you can see from the slide as Wikipedia has summarized it, you know, a patent gives the owner the legal right to exclude others from making, using, or selling an invention for a limited period of time. And that's right. I mean, a lot of people mistakenly think that a patent gives you a monopoly on an idea, and it really doesn't. It really allows you to, as the Wikipedia definition says, it allows you to exclude others from using that idea if it's covered by your patent. And the reason that's important is, if you think about it, a monopoly means you could do it, you own it, no one can challenge you, and that's not true. So for example, you may have a patent that covers a particular invention, right? And that would certainly give you the right to exclude others from practicing that idea, practicing that invention. But someone else may have a patent that blocks your patent. In other words, it's drafted broadly enough that would actually prohibit you from doing what you want to do with your patent. So that's why we typically say it's not really a monopoly, because there could be other patents out there, other IP that prevent you from using the patent, but it does give you the right to exclude others. And again, from my perspective, it gets closer to protecting the underlying idea versus in a copyright, the expression of that idea. And to get a patent, you have to prove that your invention is what they call novel, i.e. new, and non-obvious. And non-obvious means that for someone skilled in the art, so let's say this is a utility patent, which we'll get to that in a minute, for a bike harness or a bike compression system, suspension system. Non-obvious means to someone who's a mechanic or an engineer or designer for a bike company or in that space, the invention can't be obvious to them. In other words, it really needs to be something that's pretty significant that no one's thought before, not just some sort of incremental tweak on what's out there, right? And so those are sort of the two guideposts from a general perspective. It has to be novel, i.e. new, and it has to be non-obvious. And if you can prove both of those, then you may be able to get a patent. And like trademarks, patents have to be prosecuted with the Patent and Trademark Office. And so that can be quite expensive. It can take a very long time to get. COVID and even pre-COVID, but COVID hasn't helped. The government isn't moving as swift as it did. And with the Patent and Trademark Office, it never moved that quick. So it's something that if you do want to apply for it, just understand it's probably going to be, it could be several years before you actually get a patent. Let's talk, I alluded to this a little bit, the types of patents that you can have. There are two types, design patents and utility patents. A design patent is really getting towards what we call ornamental design of a functional item, right? It's industrial design. An example would be, here on the slide you can see Crocs, right? So the design and the look of the Croc, that can be subject to what's called a design patent. What you typically tend to see more often is what are called utility patents. And a utility patent is a process, and that's why I was sort of talking about at the outset, more towards an idea. I've got an invention, it does certain things, and I want a patent that protects that idea, right? And so an example of that, and I sort of alluded to it when I first started talking about patents, an example would be a mountain bike suspension, right? And the functionality of it. That's an example of something that would be a utility patent. Okay, last but not least, let's talk about trade secrets. So trade secrets are typically, think like the Coca-Cola secret recipe or formula. It's a formula or a practice or a design, something that you keep as the owner of it confidential, hidden away from the world. You don't show anyone it because if you showed it to them, they could very easily copy it, etc. and so forth. So a trade secret has value in not being known, right? As opposed to a copyright is obviously can be out there, a poem, a video, a picture, etc. and so forth. A trademark by definition has to be out there to have protection, right? You're uniquely identifying the source of a good or a service. A patent, those are published when they are issued. If you get a patent, they are published for the world to see. So as opposed to the first three we talked about, trade secrets have their value for just the opposite reason, because they're not known, they're not publicly disclosed, they're kept secret. And only so long as they're kept secret do they have value. So that's the big distinction between that as opposed to other ones. And again, as I alluded to, the Coca-Cola recipe, the secret formula, is probably the best example of a trade secret. So I know that's a quick overview, but hopefully you found that useful in terms of getting your 101 on basic IP and being able to understand and identify the difference between the four main categories of intellectual property. Thanks for listening and take care. Bye-bye.